Following on from my previous two videos about the 5-year-old cyclist, both of which I will link in the description below, I thought it was really important that I talk again about the safety aspects of a young child cycling in the middle of the road. Because a lot of the discussion has circled around the right to ride in the road, which I'll come back to in a moment because that's a misunderstood term, and whether or not they were correct in the fact that they were in the road and the oncoming vehicle should have stopped. Now, in both of my previous videos, and I will say again, I said that the oncoming vehicle should have stopped. So that's absolutely right. So this is not to go against the father in that video or against Jeremy Vine or anybody else that said the oncoming vehicle should have stopped. That's absolutely correct. The oncoming vehicle should have stopped because it should have yielded the priority to the cyclists, regardless of whether it was a child or not. But that was heightened because it was a child. Now, if the case went to court, if there was a collision, for example, then it would be heightened by the fact that it was a child in the road on a bike, if there were to be a collision. But I do this video to emphasize these safety points because that very well could have happened, because at the end of the day, this child was in the road and the oncoming vehicle did not stop. So there was a dangerous element to this situation, and that's what I'm talking about in this video. So welcome back to the channel, my 250,000 subscribers, but if you are not subscribed to me just yet, please make sure you hit that subscribe button so that you receive my future videos. I'm a barrister who helps you understand law, and I want to make the law accessible to everybody, understood by as many people as possible. And as I said in my very first uploaded video, you may be able to find your information, the information you're looking for free on this channel, although it's not a replacement for formal legal advice. So I have to make that absolutely clear. Nothing to be said in this video should be taken as formal legal advice, and certainly not as a replacement for formal legal advice. But that said, I'm going to talk about the safety aspects of this riding in the road and some other peripheral aspects that many people may not have considered. And the way I'm going to do that is to say to you that if I were advising the father in this situation, let's say there was a collision between the vehicle and the child, or the vehicle and the father, or all three of them, if I were sitting down to look at this case as a whole, what would I say and what would I advise? Now, as I hinted in my previous video, many people come to a lawyer thinking that they will get the lawyer to just fight their corner, tell them everything they want to hear, how they win, how they fight, and so on. Now, it is true to say that the lawyer will fight and is required to fight fearlessly for their client's interests, but only to the extent that is permitted by law, permitted within the rules, and so long as it's not misleading the court. Now, in order to do that, the lawyer must always look at both sides of the case. A good lawyer cannot advise by looking at the case just from one perspective. The lawyer must always look at it from another perspective. Or as I might put it from my very first legal experience many, many years ago, there were 52 witness statements about a brawl in a pub which spilled out of the pub, and then of course everybody wrote a witness statement about it from their perspective. Now, you'll know the saying that there are always two sides to a story. Well, there is another saying that there are usually three sides to a story, but there is yet another saying. There are endless sides to a story, depending on who's telling the story, what perspective they were in, what information they have, what experience they have, what their responsibilities are, what it is they're asked to decide, and so on. This is why when it goes to a criminal court, we ask a jury to consider the case, to bring their collective experience to the court. And with their collective experience, they make objective decisions, they make subjective decisions of fact based on what the defendant says and whether or not the defendant really thought or did a certain thing at a certain time. So taking all of that together, if I were sitting down with someone in a position like this, where they had their child riding out in front of them in a road with the oncoming vehicle, by the way, if you've not seen that video, it is in my original video, which has now been restored and the copyright strike removed. You can see the video itself in my original video, which I'll link in the description below, and you can hear all about the copyright strike and its removal in the second video, which I will also link in the description below. If I were to be advising somebody in that situation, the first thing I would do is watch the clip of evidence, and indeed any evidence. I would watch any evidence that's there, I would read any evidence that's available. Of course, I would sit down in conference with the client and put questions and take the client's account of what happened. But ideally, if we have the evidence already, it's almost always better to go through what evidence is available to get an idea of what happened. Now, some lawyers will take the account from the client first, and if that's all that's available at first, then yes, of course, that's what you do first. But the reason that I and many other barristers will go through the evidence first is so that we know what questions to ask the client so that we can understand their perspective better once we've got all of the evidence that is currently available, which may not be all of the evidence that will be available, just whatever's available at that time. Now, in this case, the only thing that was available to me was this video. Now, the video clip was from the father's perspective of the child riding in the road and the oncoming vehicle. Now, there are one or two very interesting points about this. One of which is that the child had identified that the vehicle was coming forward. We don't know exactly what the child had thought. Now, there are rules about asking children questions in court. It's not a frequent thing, but it is possible. In certain cases, the children will be asked to come and give evidence. There's no specific age limit, but there are two tests to satisfy a judge as to whether or not the child is allowed to give evidence. The first being whether the child is capable of understanding the questions put to them. And if they are, then the second question for that test is, if the child can understand the questions put to them, can they go on to give answers that can be understood? And obviously those answers will be useful. So if they can understand the question and give an answer that can be understood, generally speaking, unless there's anything else that would mean that they shouldn't give evidence, then they would generally be permitted to give evidence. So that's one thing to park in case that came up later. But talking about the clip itself, first of all, one thing within the clip is that the child, as I said, recognized the danger and said to the father, "Should I move over to the side of the road?" Now, in any kind of evidence, anything that is detrimental to the case is something that we have to pay attention to. Much like in a prosecution, the prosecuting authority must disclose to the defence everything that is either used within the case to support their case, but there is also a test for disclosure, which is also anything that is reasonably capable of undermining the prosecution case, or anything that is capable of assisting the defence case. Those must be disclosed by the prosecution to the defence. And so, as I said, it's always important to consider all of the evidence available. Now, that is one snippet within that clip, which to me is quite important, because the way I think about this is if I were on the other side, let's say I were defending the motorist, or let's say I was prosecuting the father or something along those lines, I would be looking at this clip and I would be saying that it was apparent at that moment that there was a danger because the child identified the danger. The father was obviously aware that the child had recognized the danger, but the father told the child to continue on anyway. Now, there is something in law known as contributory negligence. So let's go back a step and talk about negligence first of all. As a road user, whether you're in a car, whether you're on a bike or a motorbike or driving a lorry, whatever it might be, you have a duty to other road users. This is where you could be driving without due care and attention, you could be dangerous driving. If you breach the duty that you have to other road users to pay them reasonable care and attention, then that's where the offence comes from, driving without due care and attention for other road users. Now, when we've established a duty of care, which is not generally difficult, if you've done something, acted in a certain way that breaches that duty, that may then lead to a negligence claim. Now, this is the basis upon which most insurance claims are dealt with, because one driver is alleged to be driving negligently in that they, and then a whole list of negligent ways that they were driving. Failed to give way, driving too quickly, failed to slow down, failed to recognize that someone else was in the road, failed to obey the street markings, which is another important point here because there was a cycle lane to the left-hand side of where the child was going. Now, I commented in my original video that those little bit of cycle lanes to the left don't really help much because it's a little bit to the left and then you come out again from the parked cars. So all in all, I don't think that is particularly useful. But nonetheless, that's something else that a lawyer on the other side would pick up. They might say that they should have been in that cycle lane bit on the left-hand side, and therefore they would have been emerging around the parked cars, and therefore ultimately, because they would have been coming out, the other vehicle may have already been there. It may have lowered the detriment of their own actions whilst pulling out from behind that car. But nonetheless, coming back to negligence, we all have a duty to take reasonable care for each other, and that specifically applies when you're out on the road. Now, contributory negligence. So let's say another driver was driving negligently, but you were also speeding. You were exceeding the speed limit, or you were driving outside of your lane or something else. So in essence, you're both driving negligently. Then whilst the other driver may be found to be negligent, you may also be found to be negligent. Now, whilst it might be the other driver who was the most negligent and the most liable, which is a finding of fact that the court could make, the court could find that the other driver was negligent and that the collision was caused by their negligence. If the party who you are representing had also done something that could be considered to be wrong, they could be assigned a percentage of contributory negligence. Now, I don't know what you think the percentage might be, because it works on a percentage. Maybe you'll drop in the comments below what percentage you think somebody can be contributory negligent in their own claim. So whilst you're typing that out in the comment section below, this is something that often law students will struggle to grapple with, because the very wording of it, contributory, sounds that you're just adding a little bit of blame to yourself to detract from the claim. But in fact, hopefully you've written it down by now, you can be 100% contributory negligent within your own claim. In other words, the court may come to the conclusion that the other driver was at fault and it was the other driver that caused the collision by their actions. However, this driver could be so negligent that the contributory aspect of it could be ascribed to 100%. Which obviously means they get nothing, even if they win the claim. So they could win the claim in the sense that the other party was liable for the collision. However, they might be so negligent that it's valued at 100%, meaning they get nothing. So thinking about this situation, if there were a collision in that scenario where the father was following a 5-year-old child in the road and there was an oncoming car, we would look at various things, such as the age of the child, the distance, the speed, the size of the road, and all of that sort of thing. Now, as I've said in many videos before, no one has an absolute right of way on the road. There is just a hierarchy of priority when vehicles should give way to other road users, and in certain situations where vehicles must give way to other road users. Now, taking all that aside for a moment, thinking about the age of the child that was cycling in the road. There is no specific legal age limit that a child must attain before being able or being permitted to ride on the road. However, there's a lot of guidance by various charities as to what age is safe and what age they should or should not be in the road, according to these charities. For example, Brake is the road safety charity. Brake recommends that children under 10 should only cycle on safe cycle paths and away from motorised traffic. They recommend that all children wear cycle helmets, which this child was in this video, obviously to protect their head if they fell off. Cycling UK talks about chaperoning, which is riding along with a child cyclist, as in this clip here, but also talks about traffic awareness, suggesting that traffic awareness develops around the age of 8 to 10 years old, so not as young as 5. And says that this is usually the age of school-based cycle training, which they call bikeability. But it also says up until that time, at least, you'll need to supervise your child whilst on the roads, which is good in the sense that that's what happened in this first clip. But they also say he or she, the child, might be a proficient cyclist, yet make misjudgments about traffic simply because they are too young to consider different elements of the road safety at that time. This suggests that they might be judging the traffic and might misjudge that it's safe to go on when in fact it's not. But in this first clip, you'll remember the child did ask the father whether or not he should move over to the side of the road. In my view, I maintain that if I was the father, that's what I would have suggested. If I were supervising a child in that situation, I would have said, yes, well done. That was an unsafe scenario. I would have moved over if that were me in charge of that child. British Cycling also have a detailed page talking about children riding bikes. And again, they refer to the same age bracket of 8 to 10 years old. British Cycling says younger children can ride safely on the road, but as traffic awareness doesn't really develop until 8 to 10 years old, children younger than this should be closely supervised. Now, I take from this that they should be supervised and told when it's not safe, and help them to develop their road traffic awareness. But one other thing I also want to mention that a lot of these charities talk about, which I will try to remember to link in the description below so you can go and read those, I want to talk about the fact that many of these refer to the minimum age of criminal responsibility, which is 10 years old. Now, whilst it is not legal for anybody to be riding on the footpath, many people have suggested that it would be safer for the child to have been riding on the footpath, although some people obviously don't like that. But I have to agree that it would have been safer riding on the footpath than in the road, and whilst technically not legal, many of these websites do talk about the fact that the minimum age of criminal responsibility is 10. So in fact, if the child were riding on the footpath, they couldn't be prosecuted and they couldn't be given a fixed penalty. Although some potentially overzealous local authorities may criticise the parents for allowing the children to ride on the footpath. However, I think it would be a hard-pressed argument to criticise the parent for teaching the child road awareness by cycling on the footpath rather than cycling in the road. Now, I know there are lots of people that support this position that they have the right to be in the road. That's technically not true. There is not a right to be in the road. We live in a freedom-based society, which means you are generally free to do anything unless there is a law that curtails that freedom. So we live in a freedom-based society and not a rights-based society, although there has been recent talk of creating a Bill of Rights as such to transform the whole society into a rights-based system. Many people think that that will enshrine many more rights into citizens and be a much more advantageous situation. However, the counter-argument would be that currently we are free to do what we wish, so long as there's no law that prevents it. The only problem with that, of course, is that you need to know what those laws are so that you know whether or not you're breaking those laws. Some of them require intention, some of them do not. Some of them are hard regulations and you are just breaking those regulations. The same argument can be made for a rights-based system. If you don't know what the rights are, then you don't know what you can and you cannot do. Much like the Consumer Rights Act, there are lots of rights within the Consumer Rights Act, but unless you've read it, unless you know what those rights are, then you'll struggle to uphold those rights because you don't know what they are. Many of the retailers, many of the traders also don't know what those rights are, and when they do, they misinterpret them or they apply them in the wrong way. More on that in other videos. So back to the point, there is no absolute right for someone to be riding in the road. It's a freedom. But in exercising that freedom, you then have a duty, a common law duty, and in many cases a statutory duty towards other people. In the case of riding in the road, you have a duty, and in case of driving in the road, you have a duty to other road users. And one thing that's a very common discussion between lawyers and clients is that, yes, you may be right, you may be technically right, or you may be able to win this claim, or even you may likely win this claim, but how much do you want to win this claim? Because on the one hand, it might cost you a lot of money to do so. It will certainly be a lot of stress to do so, because I've met very, very few people that are not caused stress by being involved in legal proceedings, and certainly when that involves going to court. It is certainly costly, it's certainly stressful for the majority of people, that is, and there are always other ramifications. So as the saying goes, how much do you want to be right? You may be technically right, but how much do you want to force the point? Just like in this clip, if there were a collision because either the child fell over or the car swerved for some other reason, let's say a freak of incidents where one of the parked vehicles opened the door and the vehicle coming along swerved to avoid that door, didn't see the child cyclist or wasn't aware and didn't have the spatial awareness of how far away they were, which was only about half a metre, so they did come fairly close to that child. If all of those things happened, then on the one hand, you could stick to your guns and say, I'm absolutely right, I am free to be on the road. However, exercising that freedom to the limit might mean that you're ending up in some kind of collision. I read one fairly heart-wrenching comment within my last video where a child was hit in a hit-and-run incident where the vehicle just drove off, and now there's an ongoing investigation to find that driver, because the child in that case suffered a life-changing injury, which brings me on to another reason why I'm talking about this so much. Because as counsel, it falls upon us to give our opinion to a court when a court is adjudicating an amount of damages in a child injury, or worse, a child fatality. Now, parties cannot accept and the court cannot rule on such a damages amount until counsel's opinion has been put forward in court. They are known as infant settlement hearings, and counsel for both sides will put opinions forward based on various legal texts as to what amount of damages in monetary terms should be awarded based on the injuries or fatalities suffered by that child. Now, luckily, in the first clip that I was talking about, there was no collision and there was no injury, but in many cases there is. And that's why I urge you in this video, and regardless of the discussion as to whether there is a right, which there isn't a right, but there is a freedom to ride in the road, whether there is a right or a freedom to ride in the road with a child of whatever age it might be, please do think carefully when you exercise that right or freedom, or however you think of it, because there are many cases where these collisions do happen, and instead of arguing whether or not you were right to be in the road or not, instead you'll be going through a litigation where the other party is fighting, potentially, often an insurance company, as to whether damages should be paid and the level of damages that should be paid. And finally, as I said, there are some peripheral issues, because there are always ancillary and peripheral issues to a case. If there were a scenario similar to this one, where the parents, let's say, had separated and are going through a child custody battle in court, I have little doubt that if this evidence were to surface in the news and so on, that one party may bring this to the court's attention as evidence, in their view, in their argument, that they are not taking proper care of the child and that they are potentially putting that child in danger. Now, again, coming full circle back to what I would be saying in conference if a client came to me with a situation like this, one thing I would be asking is whether or not there are any other proceedings like this going on. Because if there are family proceedings like this going on, I can assure you that that is one thing that other parties would bring up. And I'll give you one example, and you can let me know what you think in the comment section below. There was one such court case where the father was drinking 3 to 4 bottles of beer each night and didn't think that that was a problem and didn't accept that that was a problem. Now, there was no issues with violence afterwards. There was no police involvement. There was no evidence that linked this drinking pattern to any kind of other violence or behavioural problems or anything like that. It was simply a complaint that was raised by the other side. Now, as I said, the father did not accept that 3 to 4 bottles of beer in the evening was a problem. Again, as I said, I'm not making a judgment. You can let me know what you think in the comment section below. But in that case, because the father did not accept that 3 to 4 bottles of beer in an evening was a problem and agreed to go on a course to do something about it and to reduce the consumption and so on, the court ruled against him in the application, and his access to the children was severely curtailed. Again, as I say, just from an issue that was raised by the other party, but was not linked specifically to any kind of violence or behavioural problems or to police reports or anything else. It was just something brought up by the other side. So you can understand that any kind of peripheral incident such as this one could well be brought up in a case such as that. Much like driving offences can be brought up in your employment capacity, because your employment contract might say that you have to have a clean driving record, no points, no convictions or anything of that nature. And if you do get those, they might give your employer the opportunity to dismiss you. Fairly, I might add, because it might be within your contract. Particularly if your contract is one that involves driving, or any part of your job involves driving, your employer might, for their protection of their reputation, might insist that you have a clean driving license. So suddenly, if you just have one drink or one drink too many, and you are breathalyzed and you are even the slightest bit over the limit and you get a drink drive conviction, your employer might dismiss you. And then there's a snowball ongoing effect. If you get dismissed from your job, you might not be able to afford your mortgage. If you can't afford your mortgage, then the mortgage company might well repossess your house. If you are a separated parent and you lose your house and you go into other accommodation, that might mean the other party goes back to court to change the order or to prevent you from seeing the children because they deem your new property to be unsuitable, or potentially FAQS or the social services consider your new property to be unsuitable for the children. And as I say, this has an ongoing snowball effect on your life. So every one little thing can have these detrimental effects. So that is why, in the grand scheme of things, I am talking about the road safety in this video. And whilst I go full circle and say absolutely the oncoming vehicle should have stopped, that vehicle unquestionably should have stopped. And unquestionably, the father and the child had not every right, because there is not a right to be in the road, but every freedom and the choice to exercise that freedom to be in the road. But I emphasize, they also had a choice as to whether or not to exercise that freedom to be in the road. If it were me, I would have put the child on the footpath, or at the very least, I would have told the child, yes, move over to the side of the road because I didn't consider it to be safe. Now, one final thing I do want to mention in this video is that I did offer to remove the original video if the claimant took offence by it and if they retracted the copyright claim. But of course they didn't retract the copyright claim and said that they didn't take offence to it. So I'm kind of glad, because I do want this message to go out, this analysis to go out, and indeed this video to go out, so that many people are aware of the dangers, and hopefully it can avoid lots of you from getting into that danger in the first place. And finally on that point, because I think one person did ask this, although that was originally offered, it was offered really as a gesture for withdrawing the copyright complaint. But of course that wasn't withdrawn, and therefore the offer falls away. But just to be clear, I maintain my views made in that video, and I maintain that it's not copyright infringement because it's fair use for all the reasons explained in my other video linked in the description below. So overall, my overarching message to you is, if you are a driver, please do watch out for other people using the road, including cyclists and especially child cyclists. And if you are a cyclist, then please exercise critical judgment, because other drivers, as I said in many of my other highway code videos, are just not going to obey the rules. Perhaps they don't know what they are, and if they do know what they are, perhaps they just don't accept them. Or perhaps they're just not paying attention at that moment. If their attention is gone just for a moment looking at the phone, then instead of noticing you coming forward because you technically have a priority in the hierarchy under the highway code, they may not give you that priority, and you may end up in a collision. So I hope this message of warning goes out far and wide. Please do spread this word to people that you know will be putting their lives and the lives of others in danger. I hope that message goes wide. I hope it's useful. Please remember to like this video and subscribe. That's how my channel grows, and I'm eternally grateful to you all. In the meantime, thank you for watching.